Chapter 11. Contracts for real estate transactions. Where a buyer under a standard contract of purchase and sale refuses to perform, the seller will not have which of the following remedies: the forfeiture of a deposit, representing 50% of the purchase price, as liquidated damages. Section 52 of the Competition Act prohibits false or misleading advertising and creates an offense punishable by imprisonment or a fine. Which of the following statements is false concerning this offense? All false advertisements made to the public will constitute an offense under the provisions of the Competition Act, even if the misrepresentation is not misleading in a material respect. Which of the following statements is true? The court has the power to enforce an oral contract respecting a disposition of land, if necessary to avoid an inequitable or unfair result where the party relying on the contract has substantially altered their position. Where a buyer makes an offer to purchase land and does not pay a deposit, a contract will be formed on acceptance without existence of a deposit. An offer to purchase real estate must by default have standard terms relating to contract assignments unless the buyer instructs otherwise. Which one of the following statements is false regarding successful negotiations? The single best thing that you can do to improve your negotiation effectiveness is to take detailed notes during negotiations. The Law and Equity Act contains provisions for the unilateral waiver by a party of a condition precedent. Which one of the following is not one of the requirements? The condition precedent has been satisfied. When completing a listing contract, a licensee should independently check information with the appropriate authority where possible. Which of the following statements about false or misleading advertising as prohibited by Section 52 of the Competition Act is false? It is not an offense under the Competition Act for the visual advertisement to create a false impression as long as the written statements are true. A seller refuses to sign a subject removal form to strike out a condition precedent from a contract of purchase and sale. Assuming that the condition was made exclusively for the benefit of the buyer, the agreement is binding. Where a condition precedent is inserted in a contract of purchase and sale, a licensee might also include a time clause. Which of the following definitions accurately describes such a clause? The clause permits the seller to require the removal of the condition precedent within a specified time if a better offer is received. Which one of the following lists accurately describes the correct criteria, as agreed upon by negotiation experts, for a successful negotiation? Efficiency, satisfaction of both parties, minimal wasted resources, preservation of the relationship. Which of the following is a true regarding listing contracts? The listing contract must be signed by all persons who have an ownership interest in the property being sold. What is the meaning of designated agency in the context of the standard form listing agreement? The brokerage appoints one or more specific licensees to act as the seller's sole agent. Misleading advertising is a criminal offense, prohibited by Section 52 of the Competition Act. Which of the following statements concerning this offense is false? The standard applicable in determining whether a statement is misleading or not is whether a consumer was actually misled or deceived. Which of the following statements about deposits is false? A binding contract of purchase and sale cannot be formed unless the offer is accompanied by a deposit. A seller refuses to acknowledge the waiver of a condition precedent from a contract of purchase and sale. Assuming that the condition was made exclusively for the benefit of the buyer and the waiver was made prior to the expiry of the condition precedent, the agreement is binding. Velma has just accepted Patricia's written offer to purchase Velma's home, which contains the following clause: this offer is subject to the buyer selling her home at address by December 31st. Which one of the following statements is true? This requirement may be waived by Patricia on or before December 31st. A contract of purchase and sale is a binding contract if properly drafted. Which of the following accurately summarizes the requirement of writing contained in Section 59 of the Law and Equity Act? 1. A contract respecting land must be in writing or it is void. 2. A contract respecting land can never be enforced against a party who has not signed it. 3. A contract for the sale of land must be contained in one written document. The correct answer is none of the above. A contract respecting land or a disposition of land is not enforceable unless there is, in writing signed by the party to be charged or by his agent, both an indication that it has been made and a reasonable indication of the subject matter. The preceding is an extract from which statute? Law and Equity Act. What is a time clause or 72-hour clause? It refers to the length of time the other party has to remove a condition precedent once the clause is invoked. Which of the following statements concerning listing agreements is true? All owners listed on title must sign the listing contract. Which of the following statements about the criminal offense of misleading advertising in Section 52 of the Competition Act is false? A representation to the public includes print and digital representations, but not oral representations. When the licensee receives a deposit in a typical real estate transaction, the licensee's brokerage holds it as a stakeholder. Which of the following scenarios is least likely to offend Section 52 or Section 74.01 of the Competition Act, i.e., the criminal and civil offenses of misleading advertising? A licensee advertises a Yaletown condo as 1,000 square feet. The condo is only 998 square feet. In order to facilitate the exchange of possible resources in a negotiation, it is important to make concessions when necessary. You have recently listed a property for sale at $850,000. An offer of $843,000 was received this morning. At noon, a second offer of $845,000 was received with a subject to financing clause. This evening an offer of $850,000 was received, also with a subject to financing clause. Which of the offers must be presented? All of the offers. An amendment to a contract of purchase and sale is generally not legally binding on the seller and buyer until finalized in writing and signed by all parties to the original contract. Which one of the following is not required in a contract of purchase and sale? The rate of commission payable. Which of the following is not a requirement for an enforceable contract of purchase and sale? Deposit. Which one of the following statements is correct? Contracts of purchase and sale can be assigned if the contract includes the standard assignment terms, the assignment does not prejudice the seller, and the contract does not prohibit assignment. Which one of the following statements is false? Unless a deposit is paid when an offer to purchase is made, there is no binding contract for purchase and sale. In a binding contract, a condition precedent can best be described as a condition that must occur before a party is liable to perform their principal obligations under the contract. Larry and Teresa orally agree that Teresa will lease 10 acres of farmland owned by Larry for 5 years. As part of the agreement, Larry agrees to build a barn, which he does at a cost to him of $10,000. Which one of the following statements is true? The lease agreement may be enforceable by Larry because he has altered his position by spending $10,000 on a new barn in reliance on the lease. Conditions precedent are usually included in contracts of purchase and sale to protect the buyer. However, since conditions precedent can also be abused by buyers, a seller must be protected when a condition precedent is being included in a contract of purchase and sale. Which of the following additions to the contract of purchase and sale is not a valid method of protecting a seller's interests? A clause requiring a property disclosure statement to be filled out can be included in the contract of purchase and sale. At common law, and unless the agreement stipulates to the contrary, as soon as a contract is signed for the purchase and sale of real property, the risk of loss or damage suffered between the signing of the contract and the completion falls on the buyer.